Good morning and welcome to the Supreme Court of the United Kingdom. This morning the court is handing down its judgment in the appeal by Balhousie Holdings Ltd against the Commissioners for Her Majesty's Revenue and Customs, an appeal from the Inner House of the Court of Session in Scotland. This appeal is about the circumstances in which HMRC can claw back from a trader the tax benefit of having received a supply which is zero rated for VAT. Zero rating is a tax benefit which the EU scheme for VAT allows member states to make available for clearly defined social purposes and for the benefit of the final consumer. In this case, the social purpose was the construction and operation of residential care homes, and the occupants of the homes were the final consumers. Zero rating may apply to supplies of the constructional materials or to the supply of the care home itself to an intending operator. The theory is that tax benefits given to the developers and operators percolate down to the occupants in the form of lower prices. Part of the mechanism for ensuring that this percolation down of the tax benefits actually occurs is a clawback of the tax benefit from the recipient of the zero-rated supply. It is called a self-supply charge, and it is triggered if either the recipient disposes of its entire interest in the care home, or if there is a change in its use, in each case within a 10-year period from the completion of the care home. The amount of the clawback is tapered down to zero on a monthly basis over the 10-year period. It is the first of those triggers, that is, disposal of the entire interest in the home, which is the subject of this appeal. In March 2013, a company in the Appellant's VAT group called Balhousie Care Ltd, which I'll call BCL, acquired the recently completed Huntley care home by a zero-rated purchase. BCL financed that purchase by an immediate sale to and lease back from a funder, Target Healthcare. The sale and the leaseback were simultaneous, so that there was no time when BCL had neither an ownership nor a leasehold interest in the care home. But HMRC argued that the clawback of the benefit of the zero rating had been triggered because BCL sold to Target exactly the interest in the care home which it had purchased from the developer. Since the sale to Target was a separate transaction from the leaseback for VAT purposes, so it was argued, BCL had therefore disposed of its entire interest in the care home. The First-tier Tribunal did not accept that argument, but both the Upper Tribunal and the Inner House of the Court of Session did. In their view, the general principles for the interpretation of VAT legislation, derived from the European Union, require that the sale and the leaseback be treated for all purposes as separate transactions. The two could not be regarded as a single transaction for any VAT purpose, including the application of the trigger for a clawback of the benefits of zero rating. This court unanimously allows the taxpayer's appeal. I give the lead judgment, with which Lord Hodge, Lord Sales and Lord Carlaway agree. Lady Arden gives a concurring judgment. The reasons of the majority are, in summary, as follows. 1. Zero rating is a limited derogation from the mainstream of the uniform EU-derived provisions for VAT, allowed to member states for the limited social purposes already described. So long as a particular element of zero rating does not trespass outside that limit, which this one does not, there is no reason to interpret the relevant UK statutory provisions, including the triggers for the clawback of the benefits of zero rating, in any different way from any other UK statutory provision, namely, by interpreting the relevant provisions having regard to their purpose, and by looking realistically at the transactions to which they are to be applied. The purposes of the triggering provision was to ensure that the full benefits of zero rating could only be enjoyed if A, the benefits continue to flow through to the occupants as final consumers, and B, The immediate recipient of the benefit, here BCL, committed itself to a long-term participation in the project of either creating or operating the care home, 10 years in both cases being a sufficient period. The change of use trigger achieved the first purpose, and the disposal of entire interest trigger achieved the second. Looking at the disposal trigger in that way, the recipient of the zero-rated supply, here BCL, would suffer a clawback if and only if there came a time when it had no continuing interest in the home, i.e., if it had disposed of the whole of its interest, with nothing retained. A person may dispose of the whole of its interest in a property by one transaction, or by a series of transactions, or even by gift. The question is not whether a particular transaction constitutes such a disposal, but whether a state of affairs, namely having no continued interest in the care home, has happened. 4. Thus, it matters not whether the sale and the leaseback were or were not separate transactions for VAT purposes. For some VAT purposes, they certainly were separate supplies of land. But whether viewed separately or together, they did not give rise to a state of affairs where BCL had, at any moment in time, disposed of the entirety of its interest in the care home. This is because the sale and the leaseback were simultaneous. There was no moment in which BCL had disposed of its ownership interest without yet having become interested as a lessee. Lady Arden reaches the same conclusion, but by applying the latest EU jurisprudence, relying on a case decided by the Court of Justice of the European Union after the judgment of the Inner House in the present case, which permits a sale and leaseback to be viewed for VAT purposes as a single transaction. The appeal is therefore allowed, and the court is now adjourned.